Welcome back to the deep dive. If you've studied negligence, you know it can be frustrating how vague that reasonable person's standard sometimes feels. A great concept, sure, but sometimes you just want a clear rule. So our mission today is to look beyond the reasonable person. We're going to investigate how specific laws, statutes written by legislatures, can actually define a breach of duty automatically. We're diving deep into negligence per se, and we'll use a really detailed Wisconsin statute about stopping rules, WSA 346.46, and a key case, Totsky v. Right-Way Bus Service, as our guide. You wanted structured legal knowledge. Well, we're using this traffic law to unlock a big concept in civil lawsuits.
That's exactly right. And think about it, a law that usually just means a small traffic fine suddenly becoming the standard in, say, a major injury lawsuit. That requires a really high bar. So we'll walk through the strict two-part test courts use. It's all about figuring out what the legislature actually intended when they wrote the law. This will show you exactly what courts are looking for when they decide, to elevate a simple rule into this automatic civil standard.
Okay, let's start right there at that threshold. If I've got a regular traffic law, what's the absolute first thing a court needs to find before that law can act as this binding civil duty under negligence per se?
Right. The court has to be satisfied on two key points, and both, critically, hinge on legislative intent. This is the general rule, the test for negligence per se eligibility. The court needs to find implied intent regarding two things. First, did the legislature actually intend for this statute to protect people from the kind of harm that happened? We call that intent to protect. And second, did the legislature also intend for breaking that statute to automatically mean someone is liable in a civil case? That's the intent to impose civil liability. Both have to be there.
Protection and civil liability, got it. Both based on implied intent. So the court is kind of reading the legislature's mind. Now let's apply this to our case study statute, WSA 346.46, the Wisconsin stopping law from the Totsky case. Before we get to what the court decided, let's analyze the statute itself using our structured method. First, what are the legally dispositive facts contained within WSA 346.46 that the court examined?
Okay, so the key facts here are the specific commands in the statute. It's not vague. It tells drivers they must stop at stop signs and yield. But crucially, it spells out exactly how and where, rules for intersections, different rules if a school crossing guard tells you to stop, and even special rules for railroad crossings. The legally important fact is that extreme level of detail. It really limits driver discretion.
That level of detail does seem important. Okay, considering all those rules, intersections, crossings guards, railroads, what was the core legal issue the Totsky court had to tackle regarding this specific statute?
The precise legal issue was, does WSA 346.46 demonstrate enough implied legislative intent hitting both those points we just discussed to qualify for negligence per se? In other words, does violating this traffic rule automatically prove a breach of duty in a civil negligence case?
Okay, and let's nail down the rule the court used to decide this. Can you state the full black-letter rule again and explicitly break down its testable elements?
Absolutely. The rule is that a statute sets the standard of ordinary care, thereby creating negligence per se, only if the court finds implied legislative intent on two distinct elements. Element 1 is implied legislative intent to protect motorists from harm. Element 2 is implied legislative intent to impose civil liability on violators. You need findings on both.
Perfect, thank you. Now for the court's elemental analysis. Let's walk through this step by step. How did the court apply the first element? Implied legislative intent to protect motorists from harm.
Well, this one was fairly straightforward for the court. They reasoned that the whole point of laws requiring vehicles to stop and yield is fundamentally safety. Traffic safety. By telling drivers exactly when and where to stop intersections, school zones, rail crossings, the legislature is clearly trying to prevent crashes and injuries. The statute itself defines a standard of care aimed squarely at minimizing risk. So because the law is inherently about preventing the exact kind of harm seen in traffic accidents, the court found element 1, the intent to protect, was clearly met, overwhelmingly so.
That makes sense. A traffic safety law intends to promote traffic safety. Okay. Now, the second element, implied legislative intent to impose civil liability. This feels like the trickier part. How did the court find that intent when the statute itself just talks about traffic fines? Isn't the court sort of adding something that isn't explicitly written there?
That's the million-dollar question in many negligence per se cases, you're right. And the court's reasoning here is absolutely key. They didn't focus on the penalty in the statute, the fine. Instead, they focused intensely on the specificity of the duty it created. You see, the legislature didn't just say, hey, be careful stopping. It laid out precisely where you stop at the line, or if no line, then relative to the crosswalk. It even covers what to do if your view is blocked. By setting such a specific, objective, measurable standard like, you can literally measure if someone complied. The court reasoned the legislature intended to take the judgment call away from the jury on the issue of breach. If you fail this crystal clear test laid out in the statute, the legislature intended that failure itself to be proof of fault in a civil case. It doesn't matter if a jury might have thought you were being generally reasonable. The shew detail, the specificity, was the evidence for the court that element 2 was met.
I see. So the takeaway is, vague law, reasonable person standard applies. But ultra-precise law, dictating distances, locations, actions. The court sees that precision itself as the legislature's signal. A signal that this specific conduct is the standard for civil liability too. Specificity replaces deliberation.
Exactly that. The more detailed the command, the less room there is to argue you were reasonable even though you broke the rule. The statute essentially defines both the duty and the breach.
Okay, so after analyzing both elements, intent to protect and intent to impose civil liability, what was the court's final conclusion in Totsky regarding WSA 346.46?
The court's ultimate conclusion was that WSA 346.46 did meet the requirements for negligence per se. Therefore, if someone violates the detailed stopping rules in that statute, they have automatically breached their duty of care in a civil lawsuit. The plaintiff just needs to prove the violation happened. Breach is established.
All right, this is where it gets really practical. Let's test this with the statute's details. Imagine this scenario. A driver stops perfectly at the painted stop line, but there's a massive snowbank right there, totally blocking the view of cross traffic.
Well,
now, the reasonable person might pause, maybe creep forward carefully. What does this specific statute demand in that situation?
the statute demands something much more concrete. It has what we can call the observation rule. Subsection 2C essentially says if you stop where you're supposed to initially, the line or crosswalk, but you cannot efficiently observe traffic from there, then the statute imposes a clear second duty. You must stop the vehicle again before entering the intersection, at a point where you can efficiently observe. It's a two-step duty if visibility is blocked. If you skip that required second stop, even if you felt you were being careful inching forward, you violated the statute, and that means automatic breach.
Wow, okay. It forces a specific action. It anticipates that exact problem. Let's try another one focused on distance. School crossings. What are the exact stopping boundaries if an adult school crossing guard signals you to stop? Not just stop safely, but what does the law specify?
Right, we look at subsection 2 meter. If directed by an adult school crossing guard, the driver has to stop not less than 10 feet nor more than 30 feet from the crossing and stay stopped until directed to go. It's a specific zone, 10 to 30 feet. So if you stop, say, 8 feet away or maybe 35 feet back, technically you violated that precise command. And because of Totsky, that violation automatically establishes breach of duty in a civil case. It just shows how negligence per se makes the standard objective, taking it away from a subjective jury call.
So not just a reasonable distance, but literally 10 to 30 feet. If the law says that, that is the standard. The detail triggers the liability. Okay, this has been incredibly detailed. Now, for our listener trying to apply this maybe on an exam or in practice, how do we synthesize all this? Can you give us that actionable diagnostic checklist?
Yes, definitely. Here's a step-by-step diagnostic for when you see a statutory violation and a negligence problem. Step 1, issue spotting. First, just identify the violation. Did the defendant actually break a specific statutory rule? Nail down the details. Was it the 10-foot rule? Did they fail the second observation stop? Be precise. Step 2, statute qualification check. Okay, does this violation trigger negligence per se? Now, for the statute, WSA 346.46, the Totsky court already did the heavy lifting and said, yes, it qualifies. So you'd note that Totsky established it meets the 2 implied intent requirements. You just quickly confirm the basics. Is the plaintiff in the protected class, like another motorist? Is the harm the type the statute aimed to prevent a collision? Usually, yes for traffic statutes. Step 3, breach conclusion. And this is the payoff. If the defendant violated this specific statute, which we know qualifies via Totsky, you then conclude. Breach of duty is automatically established. Full stop. You don't need to argue about reasonableness for the breach element anymore. The statute did the work. You then move on to analyze causation and damages.
Fantastic. So this deep dive into just one Wisconsin stopping statute really shows the power of negligence per se. Legislative precision, down to the foot sometimes, becomes this incredibly potent tool, locking in breach for civil liability.
Exactly. The precision is everything. And maybe to leave you with one final thought to chew on. Think about the part of the statute dealing with railroad crossings, subsection 3. It says you have to stop before the stop line, or if there isn't one, somewhere between 15 and 50 feet from the nearest rail. That 15 to 50-foot window, why so specific? What policy concern, maybe about safety, maybe about vehicle length, maybe train dynamics dictates that precise range? Why not 10 feet? Why not 60? Thinking about the why behind those specific numbers, that's the next level of understanding statutory application.